You are listening to the Marc Guzman podcast experience.
So let's get into the third topic, and that's receivership in real estate. So Brian, I'm going to basically summarize the story here and let you add it here because I know you have the most experience with receivership with this, and I know you have a lot to educate. Receivership is not something that many people are very familiar with, and they don't really understand how it works. Even a lot of people in the real estate industry don't know what it is and how it works. So I want you to drop some serious knowledge on us and the listeners.
So,
And just real quick before you get started, where this topic is coming from is there's a great article on berkeleyside.com that really breaks down what's been going on with a certain situation here. There's a gentleman, I'm not going to mention his name. He's 77 years old, and he has a property over on Harmon Street, which was put under receivership from the city of Berkeley. Essentially what happened was he took a duplex, converted it to a single family home, and he's been dealing with violations since 2014, and eventually the city took over the property under receivership. So, Brian, what does receivership mean? How does it work? And what's the ultimate goal that the city of Berkeley is trying to do here?
So whenever you hear of receivership or a receiver being appointed, it's usually appointed by a court of law. Most of the time, it's when a bank files a notice of default on a borrower. And a lot of times you'll see this happen with multi-unit dwellings where there's income involved. So the receiver, for lack of a better word, is the person who steps in place of the owner who is supposedly doing something bad, whether it's wasting the property, not running the property properly so that therefore rents are going down or not being collected. Or in this particular example, the city got the court to appoint a receiver because the owner of this property had made several violations with respect to the property and the building code. What the receiver is essentially going to do is take over in behalf of the owner the day-to-day activities and business of the property, whether it's collecting the rent or collecting the rent in order to pay for and repair certain violations. And usually when this takes place, the receiver charges some ridiculous, inordinate amount of hourly work or hourly charge to the property. So this is tacked on to the cost in addition to whatever defaults that the property might have, whether they're permit violations or if you're late on your mortgage and you're now in the notice of default stage, the lender is tacking on legal fees. That's usually in association with a receiver. So all of these expenses are being tacked onto the mortgage or the debt that's being weighed against the property, all with the intent that the individual starting the request for a receiver, like a bank or in this case a city, can essentially foreclose. And when they foreclose on an asset like a property like this, what happens is it goes to the trustee sale. A lot of times you'll hear of what's called a minimum credit bid, and that's the minimum dollar amount that's required for somebody to come up with, whether it's the owner or somebody outside, to pay for and cure all of the costs associated with putting the property back into the proper shape. So again, if you're losing your property with like a multi-unit building and you have all these violations or repairs that are needed and default interest or prior interest and legal fees that are accumulating, this dollar amount, this minimum credit bid is the amount that you as the borrower have to pay to redeem your property and get control of it back.
Now to quickly just give an example of how this balloons, the plan that was initially given by the receivership estimated a total cost of $180,000 for this specific property. It's now ballooned over to $675,000.
Wow. So again, put that in perspective. When this property goes to a trustee sale, there's going to be a minimum credit bid of $675,000, right? So a lot of times savvy investors will go in, they'll value the property and they'll go, oh, look, the property is either worth less than $675,000 or worth more than $675,000. So obviously if it's worth more, then outside people at the trustee sale will be willing and able to come in with cash to take control of the property. It's the same thing that happens when you have property taxes that are in default for the last 5 years. So if somebody from the outside comes in and does this, then all of these expenses that are associated to securing the property are paid, and that person becomes a new owner. The old owner could also just as well turn around and pay these expenses, right? Because these are the cost of expenses that the city deemed was necessary to cure the property or whatever violations they imposed on it. And if nobody, whether a third party outside who took an interest in the property or the owner themselves comes forward, then the title of the property goes into the name of the person who started the notice of default, whether it's a bank or it's the city. So it's a way of taking control of a property away from the owner when for lack of a better word, all hell is broken loose, whether mortgage payments are not being made or violations are being made.
Yeah, and in today's environment, a lot of people are really upset in this situation because they feel as if the city of Berkeley they were too quick to act and put the property into receivership as opposed to really researching for other options. But I mean, 5 years is a long time to correct certain violations with the city. I mean, most cities only give you 60 to 90 days to take care of it. 5 years is more than enough time. And it's also one of the drawbacks of California with all our zoning laws that
Takes
hey,
forever.
even it takes forever. But even if you have a duplex on the property and you want to convert it to a single family home and it's not really causing any damage or harm to anyone because you're living in the property yourself, well, there's still zoning laws, there's still ordinances, there's laws that you have to follow, and that's how it is here in California. Not the same in other states that do not have. There are states that do not have zoning laws, and you can literally just build whatever you want as long as you own the piece of land.
Yeah, in fact, I'd like to probably do more research on the actual case because of the fact that one, the guy was living there with his own family and he was converting a duplex to a single family. So somebody had to go over and report him to the city to make the complaint even known. Because when you look at first sight of the building, it doesn't look like there's anything readily apparent from the outside that would cause the city of Berkeley to come in and inspect the property for violations.
So the key here of this is really to make sure you're friendly with all your neighbors.
Right.